Today's topic is how to petition for your parents so that they can become permanent residents of the United States. The first thing to know is that there are two ways for them to become permanent residents, and it all depends on whether they are in the US after having legally entered or whether they're outside of the United States. And by the way, when I say legally entered, they can be out of status in the US, but when they initially entered, it must have been a lawful entry. What I commonly see is parents who've previously entered with like a tourist visa or something like that. So the first thing is called adjustment of status. That's when they're here in the US after having legally entered. If they did not legally enter, then you should watch one of my other videos on 601A waivers that I'm going to post next week. And that talks about how to fix an illegal entry and the interplay between unlawful presence and having a legal entry. Let's assume that you have a parent in the United States and they entered legally. Let's also assume that you, their child, are over age 21 and a US citizen. You can file a family petition and an application for permanent residence so that your parents can become a permanent resident. And it's a pretty straightforward process for most people. If you have any specific questions on how to do anything in this video, or you need a lawyer to help you along the way, you should always reach out to me. You could schedule a consultation directly through my website or by contacting my office. Now, there's one or two things you really need to know about this process. First of all, you cannot be a permanent resident to petition for your parents. You must be a US citizen. The second thing is that a lot of parents say that they want a green card, but they also still want to kind of live in their home country. And they just want to be able to enter more easily without having to constantly apply for a tourist visa. Well, there's a few things you should know. First of all, if they get a green card, become a permanent resident, they need to continuously live in the US. They can leave the US for several months, but if they ever leave for over a year continuously, they seriously risk abandoning their permanent residence. I've done a couple of videos on this and how to possibly salvage your permanent residence if you've been out of the country for too long. If you need any advice on that, you could reach out to me and we'll do a personal consultation. But the main key here is that they must permanently live in the US. The green card gives them the right to permanently live here, permanently work here, and to re-enter the US. But when you try to re-enter after you've been outside of the US for more than 1 year, they could stop you in the airport, send you to a back room for what's called secondary inspection, and they could try to pressure you to sign a form to abandon your permanent residence, or they can issue paperwork to place you into deportation proceedings, so that an immigration judge can determine why you spent so much time outside of the US. If the judge determines that you just intended to spend 1 year outside of the US, then you will probably end up losing your green card. If the judge determines that it wasn't entirely within your control, you might be able to keep your green card, but it's a case-by-case determination. It's highly fact-specific. If you get to that point, or you've been out of the US for more than 1 year, you should reach out to me, talk to an immigration lawyer to create a plan before you try to re-enter the United States. The more common way I see people petitioning for their parents after they've reached the age of 21 and they're a US citizen is where their parents have never been to the United States. Let's say your parent is in India. The way it would work is you would just file an I-130 family petition for them. You can go on the USCIS website and file it electronically, or you could reach out to me and I'll do it for you if you don't want to spend the time learning how to do that or risk making some mistakes or whatever the reason might be. After the I-130 family petition gets approved, you'll receive an email from the National Visa Center. It'll say notice of case creation. And basically, at that point, your case has transferred from the Department of Homeland Security to the Department of State, which is in charge of the National Visa Center and the US consulates abroad. Once it gets to the National Visa Center, you'll have to do a couple things. You'll have to pay a fee Currently, the total is $445. You'll have to fill out a visa application, or more accurately, your parent will. It's a DS-260 form, and then you'll have to upload civil documents. These can include an affidavit of support form where you, the petitioner, the U.S. citizen child, are showing that you earn enough income to sponsor an immigrant family member. Your parents will have to submit a police certificate for every country where they've lived after they've reached the age of 16. They'll have to upload birth certificates with translations, possibly marriage certificates, and other documents. After you complete everything at the National Visa Center, they'll send you a message saying your case is now documentarily qualified. That basically means the guy at the National Visa Center who looked at all your paperwork didn't find any obvious mistakes, and it's good enough for them to now send it to the consulate to schedule an interview. And the process between your case being documentary qualified and your case getting sent to the consulate for an immigration interview can be up to a year. I mean, it's usually much less than that, but I've seen situations in certain consulates where it's longer than that as well. It depends on the country. Once it gets to the consulate, they'll usually email the applicant, which is the parent, and give them instructions to complete a medical examination and to schedule an interview and to register for having their documents sent back. There's a bunch of steps. Every consulate's a little different, but eventually they'll go to the consulate for an interview, and if all goes well, it'll be a piece of paper that they put in your passport, and you have 6 months to use that to enter the United States. The moment you enter the United States is the moment you become a permanent resident, and you'll have to pay another immigrant visa fee. I think it's currently $220, so that the green card is physically mailed to your US address. A common question I get is, but what if you want to travel before that green card arrives? Actually, when you get to the airport, they should stamp an immigrant visa into your passport, which is evidence of your permanent residence for up to 1 year while you're waiting for the physical green card to arrive. And with that stamp, you can prove that you're a permanent resident, and you'll be able to travel internationally until the physical green card arrives. A couple things to keep in mind. If your parent has previously been in the United States and they've accumulated unlawful presence before they left, they might be subject to a 3 or 10-year bar from re-entering. If your parent has ever been ordered deported, there are additional steps, and it really throws a wrench into the entire process. If your parent has ever entered multiple times unlawfully, they might be subject to a permanent bar. And it's not actually permanent. It might just require that they spend 10 years outside of the US and then file this form I-212. If any of those things have happened, I strongly encourage you to reach out to me or an immigration lawyer so that we can advise you on what the actual strategy is, so that you don't waste your money on immigration forms that might not result in your parents being allowed to come to the US as permanent residents. Alright guys, that brings us to the end of today's video. If you're interested in these topics, subscribe to my channel. I'll see you guys next week for another one.